all tonight? Good. Seems cold in here. Is that just me? Is it? Well, because of the sign on the thermostat, I'm almost afraid to.
It says you can touch it, we can't.
But if you don't tell, I won't tell. If I get fired, it's y'all's fault. Maybe we can use the defense of necessity. All right. Stephanie Morrison. Miss Morrison, can you help us with McIntyre versus Ballantyne when we get to it? Cole Brown. Mr. Brown. How about Brown versus Walmart? And I'll talk about the others. So we've been talking about defenses to negligence. And last time we saw that a defendant who is contributorily negligent recovers nothing, right? A defendant, though, who is remotely contributorily negligent recovers something. Yes? So he recovers his damages, but those damages are reduced to reflect the fact that he, at least in some way, contributed to his own injuries. And then we saw that if the last clear chance doctrine applies, a negligent plaintiff recovers fully. Remember that? So we go from no recovery to some recovery to full recovery. And then as far as assumption of risk is concerned, part of that defense, per Perez versus McConkey, will still preclude a recovery outright. Part of that defense is now analyzed under duty principles. And part of it can be considered when assessing relative degrees of fault, depending on the type of assumption of risk. Again, all that Perez versus McConkey. So all that was last week. Tonight, we take up another defense, and in some ways, this one is the most important one of them all. Because as I hope you'll come to appreciate, if you don't already, comparative fault is the sum total of all the above. By way of introducing the subject of comparative fault, I would say, first of all, that the vast majority of states, not all, but most states, have either by statute or by judicial decision have adopted a system of comparative fault in one form or another. And basically what comparative fault does is permit a plaintiff who is negligent, or at least bears some fault for the bad thing that happened to him, to recover damages, but those damages will be reduced by whatever percentage of fault is assigned to that plaintiff. So where the plaintiff is shown to have been at fault, he's negligent. He's deviated from a standard of reasonableness. The jury will weigh the plaintiff's fault against that of the defendant's fault, assign a percentage to both, and then the plaintiff's damages will be reduced by that percentage assigned to him or her. Let's take a simple example. Let's say the plaintiff runs a stop sign and hits the defendant who is intoxicated. They're both at fault, right? They're both negligent. Plaintiff runs a stop sign, collides with the defendant who's driving while intoxicated. To keep the math simple, because lawyers and embryonic lawyers tend to not be good at math, and I'll put myself at the top of that list. To keep the math simple, let's say the plaintiff's damages are $10,000. And the jury assigns 40% of the fault to the plaintiff, 60% of the fault to the defendant. What's that plaintiff recover? His damages are $10,000. If you need to get your phone out to do the calculation, that's okay. But his damages are $10,000. The jury analyzes the case, says, plaintiff, you are 40% to blame for this wreck. Defendant, you're 60% to blame for this wreck. What does that plaintiff recover? $6,000. See how simple this is? By the way, where's the roll?
It's right here.
Okay. I said a minute ago that the jury will weigh the plaintiff's fault against the defendant's, assign a percentage to both, and then the plaintiff eats whatever percentage of fault is assigned to him or her. That raises the question, in considering degrees of fault, what is it that the court or the jury compares? This defense, after all, is comparative fault. So what is it that is to be compared when coming up with these percentages of fault? You read a case, Eaton versus McLean, that is first and foremost a premises liability case. It's involved, the plaintiff was visiting her daughter and son-in-law. She gets up at night to use the restroom, and she doesn't turn on any lights. And unfortunately for her, she opens up a door that leads to the basement instead of the door that goes into the restroom. Again, she doesn't turn on any lights, opens the door, takes a step in the dark, and down the stairs she goes. And she sues her daughter and her son-in-law for negligence. And you saw how the court analyzed that premises liability case in a way that's consistent with how we have discussed premises liability. But the reason that I ask you to read the Eaton case at this point is not because of what it tells us concerning premises liability, but because of what it says on this very important question of what is to be compared when in assigning relative degrees of fault. So let me ask you all this question. Anybody can respond. What is it that the jury is to compare under this defense of comparative fault? Eaton gives us a very clear answer to that question. What is it that we compare when assigning fault? Yes, sir.
Non-exclusive factors such as closeness of causal relationship, reasonableness of parties' conduct.
Okay, let's slow that down a little bit. The court does us a great favor in summarizing in just one paragraph, long paragraph, but one paragraph of what is to be compared. And the first thing that you just mentioned, well, what was the first thing you just mentioned?
Closeness of causal relationship.
Well, before that even, more generally.
Non-exclusive factors.
Even more generally.
Should be dependent on all the circumstances.
There you go. There you go. So the court says, first of all, the entire circumstantial spectrum can be considered when assigning degrees of fault. All the pertinent facts and circumstances. But that's such a broad notion that it's not very helpful in practical terms, right? But that in general is the answer to the question, what can you compare? And the Supreme Court in Eaton says you can compare it all. And the entire, all facts, all circumstances. But then the court does us this big favor by identifying some specific things that we can use to evaluate the relative degrees of fault. What's the first one?
Closeness of causal relationship.
What does that sound like to you that we have discussed already? The court says the relative closeness of the causal relationship between the conduct of the defendant and the injury to the plaintiff. What does that sound like? Okay, remote contributory negligence. We just talked about it last week. What else? What's the second thing the court identifies?
Reasonableness of the parties' conduct.
Okay, the reasonableness of the party's conduct in confronting a risk, such as whether the party knew the risk or should have known of the risk. What does that sound like that we talked about already? What kind of implied assumption of risk? Secondary implied assumption of risk. So that's something else that goes into this comparative fault mixing bowl. What else? What's the third factor?
The extent that the defendant failed to act reasonably.
What does that sound like? That's the last clear chance doctrine. Court says the extent to which the defendant failed to reasonably utilize an existing opportunity to avoid the injury to the plaintiff. That's the last clear chance doctrine. What's next?
Existence of a sudden emergency.
We've talked about that one before. What does that sound like? That's our old friend, the sudden emergency doctrine. So that one's not new to us either. What's next?
The significance of the parties' conduct.
But the significance of the party's conduct to do what? No. Court says the significance of what the party was attempting to accomplish by the conduct, such as an attempt to save another person's life. What does that sound like we've talked about? That's the rescue doctrine. That's not new to us. And then the last one the court says is the party's particular capacity, such as age, maturity, training, education, and so on. So these are some factors that we're to use in evaluating relative degrees of fault between the parties. What the court did in that one paragraph was to take much of what we've learned so far this year and crammed it all together. Look up here. Some of you are on your phone. You're going to miss this. Right here on this podium, right here on this desk, you have to use your imagination just a little bit. There is a great big mixing bowl. You see it? It's right here. It's a big mixing bowl. And at the top, sticking out from the top of that bowl, is a big spoon. The bowl is labeled comparative fault. The ingredients in the bowl, according to Eaton, are what we used to call last clear chance, remote contrib itself, rescue doctrine, sudden emergency doctrine, and that list goes on and on. And then the court just stirs up this whole thing and calls it comparative fault. Comparative fault is nothing new to you. It's everything we've talked about in torts, pretty much. It's just combined and called something else. In that one paragraph in Eaton versus McLean, the court did what I've just described. In essence, that's comparative fault. To take all this a step further, there are different types of comparative fault. There isn't just one mixing bowl that all jurisdictions have adopted. There are different mixing bowls. There are different types of comparative fault. One type, which has a following of about 13 states, is called pure comparative fault. Under a system of pure comparative fault, the plaintiff is allowed to recover no matter how great his negligence is compared to the defendant's negligence. But the plaintiff's recovery will be reduced by whatever percentage of fault is assigned to that plaintiff. So going back to the example that I mentioned a few minutes ago, two cars collide at the intersection. Both drivers are at fault. Let's say that in a pure comparative fault jurisdiction, the jury assigns 80% of the fault to the plaintiff and 20% to the defendant. Plaintiff's damages are $10,000. What's that plaintiff recover, if anything? There you go. See how simple this is? The upside to the pure form of comparative fault, the attraction that the courts have for this version of comparative fault, is that a negligent tortfeasor pays to the extent that he or she is at fault. In other words, the defendant doesn't get a free pass or some automatic buy merely because the plaintiff's fault happens to cross some predetermined threshold. So yes, a plaintiff who is 80% to blame for the bad thing that happened to him can still recover 20% of his damages. So maybe to say the same thing a little bit differently, the pure form of comparative fault links liability with fault in its truest sense. And that is the underlying goal of comparative fault. That's the objective of this system called comparative fault. It's to link liability with fault. And the pure form of comparative fault does that in its truest sense. The criticism, so that's the upside of the pure form of comparative fault. Criticism of pure comparative fault is that a plaintiff who does bear more blame than the plaintiff is still allowed to come into court and ask for money, even though that plaintiff is largely the author of his or her own misfortune. So, in other words, you could have a plaintiff who, in theory at least, is 90% to blame, 99% to blame, really, in theory, and still recover 1% of his damages. And on the face of it, many courts have said that just seems inconsistent with a fault-based tort system. I think I may have mentioned before this equitable principle. It's really not a doctrine of tort law per se, but it is a principle of equity called the dirty hands doctrine. You remember me mentioning that, the dirty hands doctrine? I'm getting a lot of blank stares, so maybe I didn't do that. But under this dirty hands doctrine or dirty hands principle, it's the idea is, if someone is going to come into court and ask the court to invoke the power of the law and require the other side to do something, that plaintiff had better come in with clean hands. From a court's perspective, it's like, don't come in here with dirty hands, in essence, and asking me, the court, to hammer the other side with the power of the law. If you're the culpable one, or if you are even a culpable one, you got dirty hands. Don't come in here asking for money when you have dirty hands. That's a principle of equity. The way this plays out in the tort world is through this system of comparative fault. Because under the pure form of comparative fault, somebody with very dirty hands, someone who is 99% to blame for the car wreck, can litigate, trigger a legal process, which is very expensive and cumbersome for everybody, notwithstanding dirty hands. The courts have looked at that pure form, many courts, and said, that's inconsistent with a fault-based tort system. We don't want to be wasting a jury's time with those kinds of cases. Plaintiff, if you're the author of your own misfortune, sorry, you're out of luck, you have dirty hands. In these jurisdictions that have adopted pure comparative fault, the response is, to the extent someone has dirty hands, they can't recover. But to the extent the defendant has dirty hands, well, why shouldn't that party have to pay to the extent they are at fault? So you see the upside of the pure form of comparative fault, and you see the downside. But if we put on blinders and just keep the overriding goal of comparative fault to link liability with fault, it's the pure form that really does do that. The other type of comparative fault, which actually in turn consists of three distinct approaches, is bona fide, or you'll see this sometimes referred to as partial comparative fault. And here, as I say, there are three distinct approaches. The first is what's called the 50% rule, which has a following of 20-something jurisdictions, give or take 21, give or take states that have adopted the 50% rule. But under the 50% rule, as the name implies, a plaintiff can recover as long as his negligence is less than the defendant's negligence. So in other words, the plaintiff's fault let's just take an example. What if, going back to that car wreck at the intersection, let's say the jury does the weighing of the relative degrees of fault and says, plaintiff, you are 40% at fault, and defendant, you are 60% at fault. Plaintiff's damages are $10,000. Let's assume we're in a 50% jurisdiction. What's that plaintiff recover, if anything? And that's kind of tentative. We're in a 50% jurisdiction. Plaintiff is 40% at fault. Defendant 60% at fault. Damages are $10,000. That plaintiff recovers $6,000. What if those percentages are reversed? What if the jury says, plaintiff, you're 60%, defendant, you're 40%, damages are $10,000, that plaintiff recovers nothing. Now, what if the jury says, plaintiff, you are you're 51%, and defendant, you're 49% to blame for this bad thing that happened? What's the plaintiff recover there? He recovers zero. What if the jury splits it right down the middle? Plaintiff, you're 50%. Defendant, you're 50% to blame. Damages are $10,000. What's he get? $5,000. Pretty straightforward, yes? So far. Then there's a group of states that have adopted the 49% rule, which allows the plaintiff to recover so long as his negligence is less than the plaintiff's. Not equal to or less, that's the 50% rule, but less than the defendant's negligence. So the plaintiff has to be, as the name implies, 49% at fault or less to recover anything. And then, like all of these systems of comparative fault, his damages will then be reduced to the extent that he is at fault. So what if we're in a 49% jurisdiction and the jury, again, splits it down the middle, 50%, 50%? What's that plaintiff get? Nothing. The third approach under this modified or partial comparative fault has a very small following of just a couple of states, and for good reason. It's called the slight gross rule. The slight gross rule. And under this approach, a plaintiff can recover as long as his fault is slight compared to the defendant's fault, whatever that means. As long as his negligence is slight relative to the negligence of the opposing party, he's allowed to recover damages, but that recovery will be reduced to the extent of the plaintiff's fault, which is the common thread that runs through all of these types of comparative fault. Whatever percentage is assigned to the plaintiff, if he's allowed to recover at all, his damages will be reduced by that percentage of fault. So that's what all of these have in common. Where they differ is the cutoff. And in the pure form, really, there is no cutoff. And that's the criticism. So that is my introductory snapshot to the various types of comparative fault. Now, comparative fault does get a little more involved when there are multiple tortfeasors in the case. And that will raise generally three issues that I just kind of want to set up at this point. And then we'll talk more about them when we work through McIntyre versus Ballantyne and some of these other cases. But the first general issue that you have to work through when there is more than one tortfeasor that caused or at least contributed to the plaintiff's injuries is whether the fault of the tortfeasors will be aggregated or analyzed separately. In other words, I don't even see a marker up here. What if that's wore down to the nub? I don't know if that'll work. There we go. Let's say plaintiff is 40% at fault. Keep this easy. Two defendants. Defendant number one, 30%. Defendant number two, 30%. That does equal 100, right? Yeah. It always must equal 100. And sometimes we've had cases where the jury will come back with their verdict form and the judge will total up their numbers and it doesn't equal 100. It's like, uh-oh, we got a major problem here. But the question is, do we compare this 40 with this 30 and then compare this 40 with this 30? Or do we aggregate the fault of all the defendants and now compare this 40 with this 60? The courts are split. The majority rule is that the jury will assign a percentage of fault to all culpable parties, like in this example. And then when it comes time to ferret out the recovery itself, assuming the plaintiff can recover it all, the majority of courts will total up the fault, will aggregate the fault of all the defendants, and then make the comparison. The minority rule then is just the opposite. The court will compare the plaintiff's fault to each individual tortfeasor. That's the first general issue. As I say, we're going to talk more about this in a minute. The second concerns the limited liability of each tortfeasor. Basically, well, let me rephrase that. In theory, each tortfeasor pays only to the extent that he or she is at fault. So the concept of limited liability is a hallmark of comparative fault. If a defendant is only 30% at fault, he's only liable for 30%. The idea behind liability is what? To link liability with fault. To say that same thing a little bit differently, a tortfeasor only pays to the extent that that tortfeasor is at fault. Or at least that's how it's supposed to work. Did it work that way in Brown versus Walmart? We'll see in a minute. The third question, the third general issue, is how the courts treat non-party tortfeasors. Of course, a party tortfeasor is, as the name implies, a party to the case. They are a defendant. But what if you have a situation where there's some tortfeasor that caused or contributed to the plaintiff's damages that for whatever reason the plaintiff decides not to sue? So they're not a defendant, but they are a tortfeasor. The question is, can you assign fault? Can the jury assign fault to a non-party? Somebody who's not in the courtroom. They're not part of the trial. They're not there. They haven't been sued. Most states have said yes. A percentage of fault can be assigned to somebody who's not even part of the case. They are a tortfeasor, but a non-party tortfeasor. This can raise very practical problems, at least for the plaintiff. Because if the jury can assign 30% of the fault, or whatever that number happens to be, to a non-party tortfeasor, is the plaintiff then going to be able to recover that 30% of his damages? The answer is no. Why? because he hasn't sued that tortfeasor. The court has no power over that tortfeasor. They're not in the case. So in order to recover this percentage, again, whatever it might be, and my example is just 30%, what does this plaintiff have to do?
Sue.
Make this non-party tortfeasor a defendant. Now he can recover whatever percentage of the damages is assigned to that party, that defendant. Now, let's take this practical problem a step further here. What if the plaintiff sues the defendant just about the time,
I think you're getting ready to say, I was gonna ask about statute of limitations.
what if the plaintiff files the lawsuit just as the statute of limitations was about to expire? Which a lot of plaintiffs do. And it's because they're lawyers for whatever reason. How can I put this? A lot of plaintiffs' lawyers don't file the lawsuit until they have to file the lawsuit. Why? Because they have umpteen dozen other fires that they need to put out, and there are deadlines associated with all of those things. They've got to deal with those deadlines, and they see, oh, I have 8 months left in filing the complaint here, so I'll get to that. For those of you who work in law firms, particularly plaintiffs' firms, personal injury firms, you know exactly what I'm talking about, right? And as that statute of limitations is about to expire, you almost feel the tension in the office start to go up a little bit because of the urgency of getting that complaint drafted, getting it reviewed, getting the client to approve it, sign off on it, and then sometimes even on the very last day. In fact, you saw some examples of this way back when we worked through the statute of limitations material. Sometimes on the very last day, you as a law clerk or as a runner maybe, you're told, stand by, be ready at the front door because we're going to give you this complaint and you're going to run it over to the courthouse before they close for the day. Yes?
Yep.
Let's say that happens. So plaintiff files the complaint against this defendant, and then the statute of limitations expires. Then this defendant says, well, it wasn't me, it was him. I'm running out of marker here. It's not me, it's him. It's this tortfeasor. But now the statute of limitations has expired, and the plaintiff knows, whatever percentage of fault assigned to this tortfeasor, I'm going to have to eat. The way that the courts have fixed this very practical problem is to reopen the statute of limitations window for a short time. I mean short. 30 days, 60 days, 90 days, not very long at all. To give this plaintiff an opportunity to make this non-party tortfeasor a party. And we'll see how Tennessee addressed that issue here in just a minute. But make no mistake, in the vast majority of jurisdictions, a non-party tortfeasor goes into the comparative fault mixing bowl, even though they're not part of the case. Let's go ahead and talk about McIntyre versus Ballantyne. Ms. Morrison, tell us about this case. I'm gonna get my glasses.
Okay.
Sorry. The floor is yours.
Okay, so the plaintiff is Harry Douglas McIntyre, and him and Mr. Ballantyne were involved in a crash early in the morning. McIntyre pulled his truck onto the highway from a truck stop and was struck by Ballantyne's tractor. Both parties had alcohol in their system. McIntyre's blood alcohol was 0.17, which was above the Tennessee statutory presumption of intoxication. And evidence suggests that Ballantyne was also speeding.
So both are clearly negligent, right? There's no question about that. In fact, these facts sound a lot like the hypothetical that I mentioned, at the outset of our discussion, right? Two cars collide at the intersection. There's nothing factually complex about McIntyre versus Ballantyne. Plaintiff is drunk, defendant is speeding, they collide. Case is tried, what result?
The jury found that they were both equally at fault, and under contributory negligence, the defendant won. Or they didn't owe anything to the plaintiff.
Okay, plaintiff, under the system of contributory negligence, plaintiff, you're 50% at fault, you get nothing. Case dismissed. What if the jury had found that the plaintiff, just to make the point, was 1% to blame, and the defendant was 99% to blame?
It doesn't matter.
The result would be the same. You're right. That plaintiff would recover nothing, even though the defendant is 99% to blame under a system of contributory negligence. Plaintiff appeals to the Court of Appeals. What result there?
The court agreed with they agree. I think they agreed, and then it got appealed again.
Say that again.
They just like I don't think they agreed with the trial court's finding.
Okay, Court of Appeals affirms and holds that comparative fault is not the law in Tennessee. And it wasn't. The Supreme Court grants review.
And they addressed whether Tennessee should abandon contributory negligence and adopt comparative fault, and whether or not the statutory presumption of intoxication could be used in a civil action.
Okay, so one of the issues here is whether the presumption of intoxication, presumption of impairment is something that is admissible in a tort case, and the Supreme Court says yes, it is. That's the unimportant part of McIntyre versus Ballantyne. In fact, you can just forget that part. But that was one of the issues. The other issue, which is whether Tennessee should join those jurisdictions that have adopted comparative fault in some form or another, that's what makes this case a big deal. A very big deal. In fact, I will tell you that I owe my association with NSL to McIntyre versus Valentine directly. Because the guy that taught torts for years and years before me was an older gentleman who had a personal injury practice. And when McIntyre versus Valentine was released on May 4, 1992, he decided, I'm out. I'm going to close down my practice. I'm going to stop teaching at NSL because I do not want to have to learn a new way of analyzing a tort case. He literally retired because of this case. And that created the opening for me. In May 1992. Another reason I remember that day, May 4, 1992, is because our first child happened to be born then. In that August, I started teaching him. Which, to my perspective, that really was not a long time ago. But when you just add up the number of years, it's decades. That's disturbing. Anyway, that's neither here nor there. But no kidding, I owe my association with this school, McIntyre versus Valentine. The court has to decide, do we scrap contributory negligence and all of those principles associated with it and adopt a new system? Of course, the court does that, right? My question is, why? And let's dig on this just a little bit. Contributory negligence and these other common law principles that we've been talking about, remote contrib and so forth, last clear chance, all of them, have been around for centuries, eons of time. If they have stood the test of time, they must have something going for them. What does contributory negligence have going for it? Why keep it? If you have to decide, do we scrap it or do we keep it, what's an argument in favor of keeping things the way that the law has been for a very long time? What does contributory negligence have going for it?
I have everything about the opposite. But I mean, probably for sake of keeping it because it's been around. I mean, that's what I would think is just if all the common law is already built on it, it kind of makes sense to keep it.
No, I don't think that's it.
Oh.
If you want some help, feel free.
The plaintiff should be penalized for his own misconduct. It's good to tear for self-injury. The plaintiff's negative supersedes the defendant's negligence.
There was a list. I do
First
have
two,
it.
huh?
There was a list. I forgot. I do have that in here.
Okay, so in the first 2 points, my paraphrase, that's the dirty hands doctrine. Don't come into court asking me as a judge to invoke the power of the law when it's your fault. Or at least part of it is. Plaintiffs should be deterred from contributing to their own injuries. If you have a wreck while distracted driving, you're texting, well, That's on you, plaintiff. Or that's the idea. That's contributory negligence. Plaintiffs should be, parties should be penalized when they cause or contribute to their own injuries. And then the third thing on that list that you mentioned, and then on your list that you didn't mention, but you said you have a list,
You have it.
is what we talked about last week. You remember what is happening legally when a plaintiff is contributory negligent? What's happening in the background? How's the legal machine moving? The analytical framework? What's happening when a plaintiff is contributory negligent? Legally, what's happening? Well, say it again. Third thing on your list.
It is the superseding, or plaintiff's negligence is the superseding, defendant's negligence. So
Yeah,
it breaks the
remember
whole
that?
chain.
Remember that? That is why a plaintiff can't recover legally, because his or her negligence supersedes the defendant's negligence. That has the legal effect of breaking that proximate chain of responsibility. So those are three reasons that the court identifies for us that maybe things should just be kept the way they are. But as you pointed out, they go the other direction. Why? What's the problem? If it ain't broke, leave it alone, but it's broken. But how is this system broken?
It allows the defendant who's primarily responsible for the act to escape liability.
That's right. If I'm a culpable party, I contributed to the plaintiff's damages, I get a free pass, even though I'm 99% to blame and the plaintiff's only 1% to blame. I get a free pass. The court says, that just doesn't feel right, it doesn't look right, it doesn't sound right. But it is the result of a system of contributory negligence. And that result just doesn't sit well with the court. Why else? What else is problematic?
There was a conversation about the legislature. I don't know if that,
No, not really.
no, okay.
No.
Then
Remember the exceptions to contributory negligence we talked about?
so like that it's not an absolute bar if there was intentional conduct, grossly negligent conduct, or through the last clear chance.
Yeah. Or where the plaintiff's negligence is deemed to be remote. So the way the law developed over time was you had this blanket no recovery rule, but because the rule was so harsh, the courts created all these common law exceptions. So that by the time this case comes before the Supreme Court in 1992, tort law had become this hodgepodge of a rule with all these exceptions. That nearly swallowed up the rule. Say the same thing a little bit differently. The law had developed in such a way that things just got complicated. And so the court decided to use this case as a vehicle to hopefully simplify things. So the court does decide to scrap contributory negligence and its corollary principles and adopt a system of comparative fault. The question then becomes, what type of comparative fault should we adopt? Does the court adopt the pure form of comparative fault? No. How come?
They say that they don't agree that a party should be able to recover even though he may be 80, 90, or 95% at fault. They just don't think that if you're that much at fault in your own accident, you shouldn't be able to recover.
No, the court does say expressly the pure form just doesn't seem consistent with a fault-based tort system does. So then the choice becomes 49% versus 50%,
They chose 49.
49%. So what is the holding of McIntyre versus Valentine? Be very careful here. What is the holding of McIntyre versus Valentine?
That it's remanded?
No, that's the disposition.
Okay.
What's the holding?
Um,
The court didn't want anyone to have to guess as to its holding.
so it lists the system,
You know,
not after that.
I'll give you a hint. The sentence begins with, "We therefore hold." We therefore hold that so long as the plaintiff's negligence remains less than the defendant's negligence, the plaintiff may recover. In such a case, the plaintiff's damages were to be reduced in proportion to the percentage of the total negligence attributable to the plaintiff. That's the holding in McIntyre versus Valentine. Now, you've read enough cases at this point in your legal education where you become accustomed to the opinion ending pretty close to where the court announces its holding. Right? Usually when you get to that kind of phrase, we therefore hold, or we find, or we are persuaded that, or we conclude that, that's where the court's bringing it all in for a landing, and the opinion ends shortly there. Not so with this one. The court goes on and writes a good bit more, particularly in Part 5 of McIntyre. And I guess my question initially, at least about Part 5, is why did the court not stop with "we therefore hold"? Why did they just continue to go and go and go?
They understand that it's going to be the trial courts are going to have a lot of things to have to figure out as they're addressing these cases.
That's right. The court was keenly aware that the trial courts, the intermediate appellate courts, and lawyers would have to figure out how to implement this new system. As I say, my predecessor threw up his hand and said, "I don't want to go there. I'm done. Goodbye, practice of law." In Part 5, the court notes that, well, let me ask it this way. What has become of contributory negligence in light of the court's holding?
They're obsolete. The court says they're obsolete. That the contributory negligence.
Well, let me be a little more precise. What about remote contributory negligence and last clear chance. What did the court do with those two doctrines?
For remote contributory negligence, it says, I see that it says the last clear chance is obsolete, but for remote contributory negligence, I'm not sure.
Okay, get some help. You got all these smart lawyers here. Yeah, the court abolishes remote contrib and last clear chance, sort of. The court notes that the circumstances formally taken into account by those two doctrines are now to be considered when assessing relative degrees of fault. That is, these doctrines go into the comparative fault mixing bowl. In case there was any doubt about that, when Eaton versus McLean came along, the court said the same thing, right? In that one long paragraph, as we talked about earlier. So let's be clear. Remote contributory negligence and last clear chance are no longer called that, but they're still very much relevant in terms of how you analyze a tort case. We just can't use those words. So in that one paragraph in Part 5, the court strips the label off, picks up the underlying legal principles, and dumps them in that bucket. What about a situation like what's on the board behind you there? Multiple tort cases. How are we to handle it? And by the way, did this case have anything to do with remote contrib or last clear chance? It did not. Therefore, that part of Part 5 is what? Dicta. What about how do we do the situation where there are multiple tort cases?
Plaintiff will be entitled to recover so long as plaintiff's fault is less than the combined fault of the other tortfeasors.
All right, so Tennessee is in the majority of jurisdictions where we aggregate the fault of everybody and then make the comparison. Did this case have anything to do with multiple tortfeasors? No. Therefore, that part of McIntyre is dicta. What about joint and several liability? That is a huge part of tort law. What did the court say about joint and several liability?
They said that it would be inconsistent to retain joint and several liability because they may impose a liability that's out of consistent with fault, inconsistent with fault.
And the court uses the word obsolete. Joint several liability is obsolete. Why? Because it can impose liability in a way that is disproportionate to fault, and that is wholly inconsistent with comparative fault. So just that one fell swoop, joint several liability becomes obsolete. Did this case have anything to do with joint several? No. Therefore, that part of McIntyre is what? Dicta. Can a jury assign a percentage of fault to somebody who's not in the case?
Mhm.
Yes. Court Part 5 says, you can do that. A party that is a defendant, a tortfeasor who gets sued, can point the finger of fault at somebody else who may or may not be a party. And then as you pointed out, the court also says, but if the plaintiff is going to recover from that non-party, they have to make a timely, key word there, timely amendment to their complaint in order to make that non-party tortfeasor a defendant. What is timely under Tennessee law? That's that statute of limitations fix. Anybody know?
Is it 90 days?
90 days. So McIntyre was decided in 1992. In 1993, 1 year later, the legislature enacted Tennessee Code Annotated Section 20-1-119, which gives the plaintiff 90 days. So that statute of limitations window opens for 90 days. Plaintiff has to bring in that non-party, make them a party before the window closes. Did this case have anything to do with that? No. And therefore, that's all good. The court did something in McIntyre that at least I have never seen a court do before. The court provided sample jury instructions and a sample verdict form. I've never seen that. Why would the court do that?
They say, I don't know. I think just to be helpful, but I'm
No,
not
that's
sure
exactly
exactly.
it. That is precisely the reason. The court, again, was keenly aware that the changes that it was making, that the changes that the court was making through this decision would completely rewrite much of tort law. And so just like with Part 5, the court wanted to be helpful, wanted to provide guidance, wanted to jumpstart this new system by providing a verdict form and jury instructions. The court's heart was in the right place in doing all the above. But if I were a betting person, which I am not, but if I were, I would bet your next paycheck that the court wished in hindsight it had never written Part 5 and it never provided these jury instructions and verdict. It was all dicta, which means it's really not binding, right? What the court held, we therefore hold, that's binding. That's not dicta. But everything that came after that, which is a lot, none of that's binding. And so the court has spent the ensuing decades, literally decades, trying to clean up what it said in dicta in Part 5. Case after case after case that did involve things like joint settlement, did involve multiple tortfeasors, did involve really quirky statute of limitations issues. And if there's one paragraph, just one, in part 5, that I'm pretty confident the court wished it could take back, it's that paragraph about joint and several liability. And you're going to see why in the next few weeks. Sufficient to say at this point, is joint and several liability really obsolete? I'll give you a heads up. The answer is not only no, but heck no. That's what McIntyre said. What does the court ultimately do with the case? What is the disposition?
They remand it for a new trial.
Send the case back, retry the case, different jury, and that was done. This time, the jury was instructed consistent with comparative fault principles, i.e. McIntyre. You know what the jury decided in the second trial? The very same thing a different jury decided in the first trial under contributory negligence. 50% plaintiff, 50% defendant. Under the 49% rule, the plaintiff then gets nothing. Same result. Very same result. This is a hard question to answer, I think. Well, maybe not. Because there's just so much you could say, so many answers you could give. But bottom line, McIntyre, for us, what is the big takeaway?
That
At
contributes.
least, what in your mind? What's the big deal about McIntyre?
That contributory negligence is no more. I think that's the biggest takeaway for me.
Is she right in what she just said? Contributory negligence is no more.
Okay, I might have overstated it, but it's not used, I guess.
What if a plaintiff is 50% negligent or more? Does that plaintiff recover?
In Tennessee,
Hmm?
no.
No. Does that not sound like contributory negligence? My contributory negligence still exists to the extent that the plaintiff's fault exceeds the defendant's fault? I think so. So what's another takeaway from? But your point is your point is the traditional system of contributory negligence. We don't do it that way anymore. The court did change that. Sort of. There's that big bowl sitting up there. There's a lot in that bowl. What else did this case teach you about the law?
That the court tries to be fair. I think like that's something that I really got from it is that they really, I think that, I don't think it's bad. Like, I think it makes a lot of sense what they did. I think it's more fair than an all or nothing.
Yeah. Okay. Thank you, ma'am. So 6 years after McIntyre, the court takes up once again the question of how to deal with non-party tortfeasors in Brown versus Walmart. Mr. Brown, you want to just take it from there? No, I meant, well, yeah.
So Brown v. Walmart, the 3-year-old Mitchell Brown, who was injured, broke his ankle. He slipped on ice and water that was just inside the entryway of a Walmart store. The ice and the water were from a self-service fountain drink dispenser within the store. And it was not known who spilled the water. Walmart had a policy that restricted.
What are the circumstances of the fall? What's this 3-year-old doing in Walmart?
I think he was just walking in with his family.
Not really.
Okay, then I'm not sure.
What's mom doing when the 3-year-old falls?
Oh, she was around the corner or was grabbing something off a shelf, wasn't watching the child.
No, not that either. You might want to just go ahead and just bring somebody in. Yeah, she's using a paid telephone to make a call. Most of you have never seen such a device, but they did exist at one time. She's using a paid telephone, which means she's tethered by a cord. And as many as, you all know, 3-year-olds don't tend to stay tethered. I mean, they're just in an instant thing, just do what 3-year-olds do. This one did, and he unfortunately slipped and fell on this ice and broke his ankle. Hence, we have this lawsuit against Walmart. Do we know how the ice got there on the floor?
No.
No. Do we know where the ice came from?
Yes. Well, I mean, it came from the fountain drink dispenser.
Okay. Do we know who spilled it?
No.
Nope. Do we know how long it had been on the floor?
An employee stated that he had checked it a few minutes before. So according to the employee, no more than a few minutes.
Okay, just a few minutes. Not very long at all. The case is tried. How's the fault to be done?
The trial court initially assigned 70% fault to the unidentified tortfeasor, and then 30% to the plaintiff, and then plaintiff's motion for a new trial. Then the trial court assigned 100% to Walmart.
What did you say about the plaintiff?
The motion for a new trial.
No, what? Well, how's the jury divide up the fault?
There's 30%.
30% to plaintiff?
Oh, to Walmart.
Okay.
Sorry.
to Walmart. And then 70% to the unknown tortfeasor. Which actually, these unknown tortfeasors, you know what they're called? I mean, there's actually a term,
Phantom tortfeasor.
phantom tortfeasors. Is that cool or what? I mean, we don't talk about phantom this or phantom that in contracts or, but in torts, we have phantom tortfeasors. Tortfeasors who are unknown. They're out there in the universe. We don't know who they are. And often can't find them. So the jury here assigns 70% to this phantom tortfeasor, 30% to Walmart, nothing to the plaintiff. The plaintiff starts jumping up and down saying, trial judge, this is not fair. I'm faultless, yet I have to eat 70% of my damages. trial judge says, I think you're right. So Walmart, you have to pay not just your 30%, but you have to pay the 70% assigned to a phantom tortfeasor. Walmart then starts jumping up and down and say, well, that's not fair. Because the goal of comparative fault is to leave liability with fault. And if the jury says Walmart is only 30% to blame, Walmart says that's all I should have to pay. And if the plaintiff has to eat 70% of his damages, so be it. That's just how the chips fall under comparative fault. So that's Walmart's all. What's the Court of Appeals do?
They affirm.
So, well, let me ask it this way. What rule does the Court of Appeals adopt?
That the third party, they must be shown by clear and convincing evidence who they are.
Who has to make that showing?
The defendant does.
Right. So if a defendant is going to take advantage of that language in Part 5 of McIntyre that says when you get sued for comparative, when you get sued for negligence, you can point the finger of fault at somebody else. If you're going to do that, and that somebody else is a phantom tortfeasor, you have to prove their existence by clear and convincing evidence. Not just a preponderance of the evidence, you have to prove their existence by a greater showing, clear and convincing evidence. If you can't do that, you can't ask the jury to assign a percentage of fault to that phantom tortfeasor. Ultimately, the Supreme Court gets the case.
Basically affirmed it.
Now, what's the court hold and why?
I'm
What's
sorry,
the
but
court hold and why?
they basically said the same thing, but it said that it's not just basically that clear and convincing evidence was not sufficient enough, and so it has to be a greater standard than that.
Well, what's the greater than clear and convincing evidence?
They must be identified sufficiently. They said.
So, okay, so they have to be identified by something more than clear and convincing evidence?
They said that clear and convincing evidence was not sufficient.
I agree with the first part of what you said. The Supreme Court, going back to its dicta in McIntyre, concludes that if a defendant is to be permitted to ask the jury to assign a percentage of fault to a non-party tortfeasor, that defendant has to identify that person. There is a big difference between proving existence and proving identity. Clearly, someone spilled this ice and water, right? So, to prove their existence is easy. This ice and water didn't just get there under its own power. Somebody spilled it. Someone put it there. So the existence of the non-party tortfeasor, you can show that by clear and convincing evidence. But that is not the standard. That's the standard the Court of Appeals adopted. The standard that the Supreme Court adopted was identity. Even if existence is proven by clear and convincing evidence. So you don't have to prove identity by clear and convincing evidence. You just have to prove identity sufficient to allow the plaintiff to sue that person. Bring them into the case. If you can't do that, defendant, you can't point the finger of fault at that person. They don't go in the comparative fault mixing bowl. Let me ask you this last question. After Brown versus Walmart, can a defendant still argue or raise as a defense, if you want to think of it in those terms, he did it, I did not?
Yes.
Yes. I don't know who he is. That is a phantom tortfeasor. I don't know who he is. I can't prove it. But he did it. I did not. Can you do that after Brown versus Walmart?
No, because their identity must be shown.
I think you can do that after the Brown case. Another way of asking the same question is, can a defendant argue that the plaintiff failed to prove causation? Yes. In which case, there's no fault to divide. So, Brown applies when the defendant says, it wasn't just my fault, it was also his. In which case, he better prove identity. But that doesn't mean, it doesn't preclude a defendant from arguing, I'm not the cause of this. Plaintiff, you did not prove one of the 5 essential elements of negligence, causation. It wasn't my fault. I'm not the cause and fact of this bad thing. In which case, there's no fault to divide. You don't even get to the question of comparative fault. Clear as mud? Let that just sink in a little bit. And then if you need to reread Brown in light of our discussion, do that, and it should make sense. And if you're lost on McIntyre, you definitely need to read that. McIntyre is what created the problem that the court had to address in Brown. Thank you, sir. So let me ask this last question and we're done. Anyone can answer it. What if the plaintiff knows the identity? So plaintiff files suit, defendant points the finger at somebody else and says, attribute some of the fault to this somebody else. And plaintiff says, I know who that somebody else is. I just chose not to sue him. Can the jury assign a percentage of fault to that somebody else, even though they're not in the case? Yes. Now, what if the statute of limitations is expired against that somebody else? And the plaintiff wants to bring them into the case, but they knew who they were when they filed the lawsuit. Can they still bring them into the case? Yes. Who says? The Supreme Court in Becker versus Ford Motor Company. So the fact that the plaintiff was aware of the identity of that third party doesn't somehow prevent them from taking advantage of that extension of the statute of limitations. That was Ford's argument. Ford gets sued, and then Ford said, oh, it's really your son's fault. So we're going to ask the jury to assign some of the fault to your son. Plaintiff then tries to sue son. Ford says, well, you can't do that because you knew it was your son. The Supreme Court, in an opinion written by Dean Koch, rejected Ford's argument and found in favor of the plaintiff. Fasten your seatbelts. This is going to get better. We're out of time, so
For the purpose of the exam, so you put a hypo on there, which one should we focus on?
come up here. Come up here. We're out of time. I got to let you go. All right, make sure I get the roll.